Hey, right, everyone, welcome to the live stream tonight. I was just faffing around as usual. So, for those who haven't been here before, we're just going to try and crunch through some questions that have come in, either on the channel or in the live chat. A couple of things you've got to know. One is that it's not legal advice. We're going to do our best here to be helpful, but it's yeah, often quite difficult to really understand the background. So basically, the best kind of questions that we can answer are ones which are quite small and short and self-contained, because that just means we can kind of apply general principles easier. And also, if you're going to put questions into the live chat, please don't disclose personal data, as in don't ask questions about your own situation. You obviously can, but you just need to frame it like an anonymous what if question. So rather than asking how long can a family with kids be in B&B for, like as in like I'm in it, just phrase it as a general kind of question, if that makes sense. So no, there's some other questions coming in last minute. So for those who submit questions during the week, I basically go through the notifications at about 6 p.m. So if you leave it later than that, you probably won't actually get the questions put into the actual live stream. So just bear that in mind, guys. But we'll get to it. I don't know of any particularly interesting news or anything this week. I think there is a new homelessness minister. I did just see something about that, and they did mention some action plans which in no way will end homelessness. But what were we expecting? So I guess that's, yeah, not that surprising. But yeah, so first question that's coming from the channel is this one here. So, single mother with three children living in a two-bedroom housing association flat. All three of her children have a diagnosis of autism, essentially, and two with possible ADHD, which are awaiting assessments. And she has a letter stating that one of her sons requires his own room as he can become quite aggressive. The age of the children are a boy of 12 years, a boy of 9 years, and a girl of 6 years. She has been in the flat for around, as in the mum's been in the flat for around 9 years. She does bid on properties, but they're very rare. Should she apply for a homeless application, would this help her in any way? So this is essentially, it sounds like someone who is, well, I guess would potentially be under the sort of yeah, under a transfer in terms of potentially applying. It depends slightly on the local housing allocation scheme how it's working here. But basically, what's probably not happening here yet is that they haven't been accepted as homeless. So I guess the question is, in this situation, does this, yeah, is it reasonable to continue to occupy this accommodation on the information we have here? And hey, right, Martin. Nice to have you here, mate. So yeah, I mean, basically, I'm going to be honest with you. I don't know how kind of clear cut the answer can be here. It's quite difficult. I'm going to assume here that the letter stating that one of the sons needs to have their own room is going to be someone with some kind of specialism in it. So maybe, maybe a medic or, something like that. In order to kind of have that assessment. And yeah, so the question would be: is it reasonable to have a family of four living in a two-bed home where three of the kids all have disabilities and one of which has been assessed as having their own room? What's the chance of making a homeless application? I guess the one thing I can say that is definite is there's nothing to lose by making a homeless application, because if you were accepted as homeless, it's likely that that's going to increase lead to an increase in your banding, which would hopefully speed up the process of getting rehoused, although it still might not be very quick. So there's nothing, you don't actually lose anything in this situation by triggering an application, because the worst that's going to happen is the council will simply say, yeah, you're not homeless, we don't accept it. They have to give reasons for that in a written decision. And in effect, you can analyze the logic that they've used and work out if you think it's rational or not based on what they've kind of concluded. So it's a difficult one. That's probably as much as I can say on it, really, because I'm trying to think of similar cases I've had before. Um, I can think of a similar situation. I worked with a family where the mother had like a physical disability, and she was having to sleep on the sofa basically without a proper bed, and she had a spinal problem, so that was kind of very clearly not okay. Um, but that was a bit of a struggle, to be honest. But yeah, as I say, there's absolutely nothing to lose by starting the process and just see what happens. So, Will or Karis, I don't know if you've got any experience of these kinds of cases. You can be a bit more optimistic than I have been. Um, yeah, as I say, it's a rather complicated and grey area, I'd say.
Yeah. I mean, the problem is that you can I mean, if you want to just make an application for social housing, you can do that, but you can just find yourself waiting for a very long time. Um, and unfortunately, I mean, I always sound like, I mean, just before came on the air, as it were, we were discussing this, and I generally don't get involved very much with people arguing about whether they're entitled to social housing or where they should be in the queue because the queue's so long, it's very difficult to get a result where somebody gets an offer of social housing in a short space of time. And so I think what you just have to overcome is the sort of negative feeling towards the private sector. I know that it's well earned, but I mean, it isn't reasonable for a family to be living like that. And I would say go make an application as a homeless person. And I mean, you can ask them to help you I mean, as part of that, because you could say, well, help us make an application for social housing, and they could help you do that. But the problem is, you won't necessarily get anywhere with that. But whereas you would be entitled to, if they accept that you're homeless, then they would have a duty to secure that suitable accommodations made available. But that could be just the beginning of another nightmare, really, couldn't it? If they offer you something which isn't.
Yeah.
I'm sorry
Uh,
to sound so negative.
no, no, I think this is just it's one of those ones where, in one sense, you can kind of foresee what the negative decision would say. It would kind of say, yeah, obviously it's far from ideal, and in one sense you'd be kind of expected to use your living room as a bedroom, stuff like that. But I think I guess the devil in the detail would be is has the council genuinely taken into account the needs of the kids, particularly this one who's assessed as having to need their own room. And I guess just kind of just that would be your starting point is to work out, has the council actually engaged with the issue at all. You can also expect in that process to probably get some resistance to even making the application, and kind of you have to chase the council to actually make a decision in the right time, that sort of thing. So yeah, I think I still still kind of say it's worth trying. As I say, you're not going to be any worse off. You're not going to lose your tenancy just because you made a homeless application. Um, but I think you'd have to fight at every stage if you're going to kind of, ultimately get your banding increased from what is presumably the lowest band up to something which gives you a real chance. Again, this is something where you also just want to find out what the local housing waiting lists are like how long are they? Is it somewhere in London where you're looking at 10 or 20 years, even for people who are homeless? Or is it somewhere which is a little bit more leafy and a bit further away from London where actually you've got a real prospect of getting it? So, because certainly I'd say in Bedford, it would absolutely be worth going after, because if you increase from like band D or band C up to band B, that immediately kind of gives you a realistic prospect of actually finding somewhere. Whereas remaining in band D or band C in Bedford gives you very little prospect of actually finding something unless it's a very hard to let property, which basically is a code for an absolute slum. So yeah, I think that'd be the kind of the response. And I guess in that sense, what you're going to do is get methodical about it, make sure you're triggering the application via email, including all the relevant information. And what you're really looking for is, has the housing officer actually engaged with the evidence? Have they given a good reason for departing from the assessment of this professional that the boy needs their own room? I mean, given that they're basically already overcrowded in the sense that this family need three bedrooms and they're already living in a two bed, and whether this additional issue of the one of the sons needing their own room, whether that would basically tip it over into that kind of like that kind of realm of legal homelessness. So yeah, I think that's probably all we can say about that one. So but yes, it's yeah, it doesn't make any better. There's tens of thousands, if not hundreds of thousands of people in that situation. I'm sure the cost of the country in terms of the human impact on this is going to be incalculable, really. Um, so that's the first question from the week. Second question, another interesting one. Um, so overcrowded family have a mice infestation. Environmental health have said it needs professional response, but nothing can be done whilst the property is so full of stuff due to the overcrowding. What can be done? So once this family's done the right thing, they've got environmental health involved, who have essentially said, yes, there's a real serious issue here. We need to do something. Um, but there's this kind of kind of practical issue about actually kind of carrying out the treatment. I guess what they'll be looking at is kind of looking for where the mice are coming in, and kind of in order to do that, they need to be able to see see all the walls, see the floor, see the skirting board, and so on, to see where the mice might be getting in. Um, my first, again, I don't know if I don't know if I'm right about this. My first answer when I saw this was that an argument could be made, I think, it's difficult, but I think it could be made, an argument could be made that whilst the infestation is there, it's not reasonable to continue to occupy. And it would be a little bit like a disrepair issue where the family could get decanted whilst the works gets undertaken. I don't know how long it would take to kind of treat the property in terms of the infestation, but um, that's something which I just wonder if that might kind of allow, even just a short period where the family and the belonging, well, the family could move out briefly. The belongings could be arranged in such a way that enables the environmental health to go in and sort the problem out. Whether that might kind of allow the work to be done and kind of end up with the right result. Um, but I just don't know. I've never seen anything like this myself in my own casework, so I don't know if there's anything else that could be done here to kind of allow that to happen, and actually whether the duty would still remain with environmental health to actually do the work in some way, find a way of doing it. So whether there's some leeway they've got and some stuff they can use to actually make that possible. So again, I don't know, yeah, whether you guys have any experience of a situation like that or any kind of thoughts about it. It's yeah, it's a yeah, I can understand the problem. I just don't know. I don't know enough about environmental health either in terms of how their duties actually kind of work. So yeah,
Um, I think I mean, sorry if I'm stating the obvious, but I mean, they would, again, making a homeless application would be a way forward. Not necessarily in the, I hope I don't sound like a homeless application is the solution to every problem that you face, but if you're overcrowded in the first place, then presumably you want to be rehoused. And if the mice infestation can't be sorted until you are rehoused, without you being rehoused, then that's another reason for you being rehoused. Um, and so I can't see that you'd have very much to lose. And the problem with environmental health is that I may have said before, but as a sort of active agent in local authority life, they've sort of been extinct since the 90s. I don't know if you find that, but they used to be quite, environmental health department used to be quite a sort of active group, as was sort of tenancy protection teams, that would deal with rogue landlords. But the cuts just, eliminates them. And now environmental health, they'll just write, they don't enforce hazards, and they just write letters to landlords saying, oh, we like to try and do things informally and give people a chance. So I mean, they're not much use. So the way to get a professional response might be to make a homeless application, and then you could at least get it done as part of a prevention duty as well. If there was a way you could get the mouse infestation done and still remain in your overcrowded accommodation if you wanted to, at least prevention duty would address that, because it would enable you to get things done that would make the place less unsuitable.
yeah, yeah, and thought about that in terms of like as it kind of being an act of under the prevention duty. Um, Again, I feel like, Will, your experience in London might have jaded you a bit more than elsewhere, because I'm not saying our environmental health team is great, but they are more active than how you've
Mm,
described the ones you've had dealings with. I
Probably.
was aware of a case recently where a landlord tried to illegally evict a tenant, and actually environmental health were pretty useful.
Oh, that's good.
Unfortunately, housing options weren't, but they were actually did they did do some things which helped out. Yeah, so yeah, another interesting one. Again, if I think if we ever kind of think about something else that we haven't said here, we could maybe bring it back to a subsequent live stream. But yeah, again, nothing to lose by making a homes application, see what happens. And yeah, as I say, I also wonder whether, I mean, because environmental health and housing are going to be in the same organisation, whether there might be other things that they can be doing together to actually kind of come out with a good outcome. There's the final thing I say about this is that if you look at the local government social care ombudsman database I did, that if you search for infestation or like mice or whatever, you'll get a number of cases that the LGSCO have looked into, and it's generally cases where it's in temporary accommodation, but some of the principles would absolutely apply into any kind of housing, really. So have a little look at that because yeah, but essentially, in fact, I might just bring up a couple of ones just to show you. So bear with me a minute. Well, maybe I won't actually. I've probably been going on about it too long now, but my laptop died 2 weeks ago and it's kind of caused all sorts of problems with me getting back all my information. But yeah, so maybe I won't do it right now. But at some point, I'll kind of yeah, maybe next time I'll make sure I'm primed and I've actually got the database to hand to actually show you. But yeah, it's just something that's interesting to see how different bits of the law apply within these LGSO cases because they do kind of bring it all together. So just yeah, just some helpful comments here in the chat. So thanks for this. So private rent sector landlords have a duty to keep properties in a habitable condition. Local authorities likely to put the onus on the tenant to get the landlord to sort it out. Um, Environmental health won't often investigate social housing issues, only private rented sector. So I mean, yeah, again, it's useful to know, even if it's not doesn't make things easier. But yeah, no, thanks for that. Appreciate it. Final question that came through the week that's been anonymized because we do the anonymized ones first. So is this one here? Um, what if somebody wrote off a rent arrear debt with the insolvency service, then received a N54 eviction form from housing association? Is this lawful or legal? I don't know, so I'm going to defer immediately to Will and Caris because yeah, it's not something I've kind of dealt with before. But yeah, how again how does that work in practice in terms of taking that kind of action to get the debt wiped off and the impact it then has on the tenancy?
Yeah, so well, I can go. Well,
Go for it.
so yeah, it can be lawful because the rent arrears, although it's written off by a debt relief order or an IVA, doesn't mean the person can't pursue you for the money. So that's especially with a local authority, it's the reason the rent arrears occurred. So that could still be grounds for possession. So you have like three grounds, and that's ground eight is the rent arrears themselves. And if that's zero, then that ground would fail because you have this agreement with the insolvency service. But how the rent arrears occurred and if they're persistent, which is ground 10 and 11, so that could still be an issue there. So that they could still be used, those grounds, that those rent arrears occurred in the first place. So you have to really show, they're asking you to show it's not going to happen again, basically. There's a history of debt, persistent debt, or rent arrears. So it's about, you could have a defense in saying the rent arrears ground date has failed, but you have to show that it's not going to happen again and that you've dealt with it this bit and going forward. So, but it can still be used ground 10 and 11, which why the rent occurred and reoccurring
So
rent
what
arrears.
what kind of evidence would you want to potentially show the court to show that it's less likely to reoccur? Is that is that going to be just basically evidence of how it accrued in the first place? So if it occurred because I don't know, something out of your control or something, kind of delays and benefits or whatever, then that would be that'd be evidence that it's not going to happen again. But if it was something where poor budgeting, for want of a better word, kind of
Yeah, so that example, so poor budgeting, so you could show it by you're working with a charity or the citizen advice of putting your finances all in order and actually budgeting. Um, for example, if it's your mental health and depression was the reason for the rent arrears, you're now on medication, you sort of taking the steps with the insolvency services, evidence that you're making steps in the right direction. So you've got that, I'm making steps in the right direction. My depression is sorted. I'm seeing the doctor. If it's a benefit deficit, you've now spoken to the job centre and you're now got your benefits in place and up to date and all your entitlement is there. So that could also, there are steps you can show. So whatever the reasons, there are steps to show what you can. And this is where it comes in with would it be reasonable to evict you? So this is the discretionary grounds. So the housing association have to show that it would be reasonable to evict you. And that's much higher for a housing association. So you'd have to have, you can say it was not reasonable because now you've got the rent arrears sorted. It's not going to happen again because you're working with a agency to help you budget and learn to spend your money, or you've got the benefits back in place, and your mental health is cleared because you're seeing the doctor regularly and you're now medicated for it and you're turning up to court with your paperwork. There should be someone there, court duty solicitor, that you can show all this to, but they'd have to show it's reasonable to evict you under these circumstances, and that would show it's not reasonable to evict you because you've taken steps to sort out the arrears, the debt, and moving forward, it won't happen again. So there's
Cool.
two separate bits. Although the money is cleared, you've
Yeah.
got to show it's not going to happen again, like the persistent rent arrears reoccurring.
Yeah.
There's
Cool.
a case which is I got quite a shock when I read the judgment, and it's back in 2011. But it's a case called, hang on a sec, where's it gone? It's called Sharples versus Places for People Homes Limited. And that was it went to the Court of Appeal in 2011. And in that case, the tenant had gone bankrupt. And so the rent arrears were he said the rent arrears were part of the bankruptcy debt and so couldn't be relied on by the landlord. And the Court of Appeal said they can be relied on by the landlord, because the claim for possession is not brought because you owe money, it's brought because you failed to pay the rent. And so it's the behavior of the tenant in breach of the covenant. So it's not conclusive. I'd have thought if you were relying on a case where it was reasonable, you could say, well, he's gone bankrupt, it's not reasonable. But it is a worry that in that case, in Sharples, the landlord was still able to enforce a possession order. So don't think you can sort of turn up in court and say, the money, the renter are gone, because they're not. Well, they are gone in the sense of a recoverable debt, but as I say, the landlord isn't asking for possession by enforcing a debt. They're saying that you've breached your tenancy. Sorry, I think I'm going round in circles.
Yeah, that's cool. That's helpful. Okay, nice one. Thanks, guys. I feel like there's some useful stuff there. I mean, my one experience of the court solicitor is that they're very helpful, but it really needed to be spelled out to them what the situation was. And I think if we hadn't kind of laid out information in advance, nothing would have been done. So it is really worth kind of putting your argument together. And I mean, I put it in a letter basically, just and gave it to them, and it kind of worked. So yeah, cool. Right, we're getting to there's one more question for the week, but we'll do it last because it's not anonymized. And so now we will go to the live stream. I think this is a quote from a letter from a council. So I'm advising us, this as in the housing officer is advising you that the accommodation provided to you, a temporary accommodation, as temporary accommodation is now being provided under Section 193, Part 7 of the Housing Act. So is it the main duty done? I mean, that is the main duty. I don't know if it's what you mean by done there. So the main duty is kind of not discharged until, fully discharged until the person ends up in either social housing or a decent private rented property. But in one sense, that's Section 193 is the main housing duty. I think that's what the question is, which is good. That's the good one. But then depending whereabouts in the country you are, it might be many years till you actually get your kind of home at the end of it all. So I don't know if you guys are reading that question differently from me, but does that sound about like I've understood it there? Yeah.
Yeah, um, I think you did. Although it does raise the issue that comes up quite a lot of whether there's some sort of thing that resembles a permanent offer once the main duty is engaged. Because if you're basically just given the same accommodation which you were given as temporary as your non-temporary, you think, well, is that it? Is that all I get? And the answer is, well, it can be, yeah, because if that place is suitable for you, then the only duty they have in the long term under Section 193 is to secure that suitable accommodation is made available. And I think it has to be for a minimum of, does it have to be available for 2 years for Section 193, or is it just 1 year?
So in the private sector, it's a minimum tenancy of 12 months. So, but then there's a kind of weird like reapplication thing. So if you become unintentionally homeless from that kind of offer, then you don't have to demonstrate priority need if you make a reapplication. But that's going to be quite rare because well, I guess it can happen.
So yeah, that could be the main duty then. Yeah,
Yeah,
that could
and
be
so
the main
you
duty.
might just end up in there for decades,
Yeah.
technically bidding on the housing register, but you're like, kind of a millionth in the queue.
But there's no
Um,
time limit. There's no legal time frame that they have to move you by a certain time.
yeah, so yeah, and those average waiting times show that in some areas you're looking at decades before you actually get the actual home at the end of it all. By which point your family's probably changed size and kind of yeah, it's become an academic point. Um, so next question is a multi-part. So let's just piece it back together again first. Um, First bit, come on, YouTube. Uh, Second bit, is there a third bit? Can't see a third bit. No, there is a third bit. Sorry, yeah. Um, so someone was placed in temporary accommodation after making a homeless application, but was not given the main housing duty. He then made a new homeless application a month ago, but has not heard anything from the council despite sending several emails. He's now been told to leave the temporary accommodation and threatened with a lock change with not much time left to find alternative accommodation. What can they do? Um, so I guess I don't quite understand the question. My question, what I probably need to know is why were they not given main duty? Were they not found in priority need? Were they found to be intentionally homeless? What was the circumstances that allowed them to make a new application? Was there new information? I think we might need some clarification on the question to make sense of it. I don't know if you guys can make sense of it, and I can't, but I don't quite understand the sequence of events there unless, as I say, the council initially said that they weren't in priority need, or there was some other reason why the main duty wasn't owed.
And I hazard a guess that the sequence of events is that the council held that they didn't owe a duty. And that's why when it says not given the main duty, they said we don't owe you a duty. And so they then said, we're going to terminate your temporary because we don't owe you a duty. And then he makes a fresh homeless application, and they're probably just ignoring him. So,
I
and
guess I'm
yeah.
puzzled why they're still in the same temporary. Yeah, because if they're going to end the duty, then they're probably going to end the temporary accommodation very, very quickly.
Well, maybe when they wrote the letter that said they weren't accepting the main duty, sometimes at the end of it, it says, therefore, you have to leave your current accommodation, and then it gives you a date in about a month. But they may not do anything they may forget about that. And it's only when you get another letter saying, or, you've got to go, or the one where they say we're coming to change the locks. I mean, he may have then made the fresh homeless application after getting the negative letter, and then a bit later gets the changing the locks bit, but I'm guessing. So
Yeah. I mean, if the person asking the question just can clarify that a little bit, that might help us just give a better answer. Meanwhile, we'll do the next one, which again I think is a multi-parter. So let's piece this one together as well. Um, Make sure I'm not mixing them up here. Is that it? Oh yeah, so there is some clarification. Yeah, so I just think yeah, cool. I'll come back to the question 5 in a moment. So question 6: what if someone is on the interim accommodation duty? I guess that means can they apply for a suitability review on how many days when he get the interim accommodation? Can they also review medical ground as the housing officer did not consider that? Have I missed a bit? Sorry, guys, just maybe see if I missed a bit there. Didn't see. Okay. So I'm not sure if there's a missing part of that question, but I'm not quite following it. The housing officer gave the PHP after 2 months and 20 days later. How to challenge that? Waste my 80 days and then prevention duty. So if you're getting interim accommodation, then the prevention duties should not be applying because the prevention duty is owed to people who are threatened with homelessness, and the interim accommodation duty is owed if you might actually be homeless. So yeah, the prevention duty should have ended the moment Section 108 interim accommodation is provided. I don't see how that wouldn't kind of happen. Um, so let's just kind of answer the questions we can. So can you challenge the suitability of, well, can you challenge how many days that you've been in interim accommodation? Again, I'm not quite sure what this is trying to actually say. So you can, if that's the question, you can certainly challenge council delays to actually reaching the final decision. So if you made a homeless application, you place an interim accommodation, the relief duty starts, and then 56 days later they don't make a decision and there's no particular complexity with the case, then you can complain about it at that point, and that will hopefully result in the council putting their finger out and basically making the decision. So that's something you can do there. Can they also review medical ground as the housing officer did not consider? We don't have the rest of that question there, so I'm not sure if we can answer that. The housing officer said they cannot send the PHP due to admin error. So I mean and the housing officer gave the PHP after 2 months and 20 days. So again, you can complain about that delay because the whole point of PHP is to be done at the beginning of the relief or prevention duty, so it actually gives you time to prevent or relieve your homelessness. So there are some LGSO cases where people get small amounts of compensation, like 100 quid, because the council didn't issue the PHP when they should have. And I guess if that then kind of messed other things up for them, then that compensation might increase. And one of the things the LGSEO can also do is basically get the council to in effect backdate when what the final decision and stuff. So if you were if the council took a year to if they delayed it for a year and that resulted in a delay of a year getting onto the housing register, then one of the things the LGSEO would do is get the council to give a different effective start date for that banding, so they can kind of backdate your start date in the band, so that kind of increases your priority. So yeah, hopefully, I don't know. As I say, I think I've answered the bits we can answer there. Might need some clarification on that. Whilst we're waiting for clarification on question 6, let's go back to question 5. Clarification on question 5: the council didn't find the applicant in priority need, then they make a new application based on new evidence. Okay, yeah, that makes sense. Um, so let's just kind of go back through the questionnaire with that new information. So, place in temporary accommodation, found not in priority needs. New information was found, or the circumstances of that person changed in terms of their mental health might have got worse, for example, and so they make a fresh application, and now okay, and so this is obviously happening in quite rapid succession. Unless, as Will suggested, they've just literally forgotten about their intent combination. So I guess, I mean, what can they do? In one sense, you have a situation here where really it's as if the previous application didn't happen, and you're just making a fresh application, and there's the council saying there is no reason to believe that you might be in priority need. Now, legally, that is going to be very, very questionable, unless the change in circumstance or this new information that has kind of prompted the fresh application is trivial. And a lot of the time, trivial, as in like has no consequence. Most noticeable changes in mental health issues or other health issues or other things relevant to vulnerability will be more than trivial. So the council should be treating the application from scratch. If there was a question to be asked last time and they eventually found that the person wasn't in priority needs, but then there's new information which suggests that that person's a little bit more vulnerable, then legally speaking, it should be treated as a fresh application and they should go through the whole process again. But challenging councils on this point is quite difficult because you essentially need a solicitor. You can complain about it, and the LGO can provide compensation a year later, which is, by which point it's not a lot of use. But that's kind of, I think, the position. So really, you need to get a solicitor to threaten judicial review to get the council to accept Section 108 is kicked in again, and kind of almost treat it as if it's just a brand new application. So yeah, again, if Willa Harris want to add anything to that, then you're very welcome to. But yeah, if not, let's see if we get clarification for question 6, which again seems like there's quite a lot going on in this question. What if the housing officer said end of prevention duty after 80 days, but the team leader of the housing officer said the prevention duty was not accepted? What to do? I mean, so technically speaking, the easiest way to challenge that is to do a subject access request to get a copy of your records from the council and then see if the prevention duty was accepted or not. If I'm honest, don't bother fighting about the prevention duty. It's a waste. Yeah, my opinion, it's not a lot of good really, particularly if this person is now in interim accommodation, so is now homeless. It's now an academic point, so you can complain about it and get a little bit of compensation potentially down the line. But right now, it's more important that this council actually follows the law and houses the family if there's a duty to do so. So I suggest that would be what I'd be focusing on in that situation, is to kind of make sure the council is now actually carrying out the right inquiries, they're engaging with the relief duty properly, they're making a good decision about priority need and so on. That's actually more important. The fact that whether or not the prevention duty was done properly, honestly, I don't think it actually matters that much. As I say, it's an academic point at this stage, I'd say. Again, Will and Karis can correct me on that if they think differently, but I don't see much to be gained by pursuing the council's failure to kind of discharge the prevention duty properly if you're now homeless. What's more important is you actually kind of deal with what you have now properly. Um, so next question, multi-parter. First part, second part. Family with children had the relief duty accepted at the beginning of August, but no interim accommodation has been provided. So, as in a family which, yeah, okay, so they're in priority needs, and the council's accepted they are in fact homeless and they are in fact eligible. So the interim accommodation duty absolutely has been triggered. The 56 days of the relief duty is now passed, and still no interim accommodation has been offered. There has also been no update regarding the main duty. They recently received an email from the housing officer saying they will make the necessary arrangements for Don't know. Just going to check I'm actually seeing all the questions here. That might be an issue. All messages are visible. Let's see if that adds anything to it. Nope. So, okay, let's just answer what the question is there. Yeah, so basically, this is just pure gatekeeping of Section 108 temporary interim accommodation. The family need to complain probably now. In this situation, it doesn't matter that much that you annoy the council housing officers in terms of making a complaint against them, because they're automatically in priority needs. The council's already accepted they are homeless and they are eligible. So, the only question that really would be outstanding would be whether or not that they're intentionally homeless. Let's assume that they're safely that they're not. There is no reason to push this really hard and just push the council to make the final decision. Another situation where you could potentially involve local councillors just to kind of chase the council and get them to actually issue a decision. But yeah, legally speaking, the relief duty is only triggered once the council is sure that you are homeless and sure that you are eligible. So those questions are basically dealt with. Yeah, the kids make you automatically in priority needs. It should be fairly straightforward. It's just another case of council delays and weaponized incompetence. So yeah, that's probably the answer. As I say, there might be a little bit more to it that I've missed, but that's the answer to the question that's there anyway. I think that's it. Cool. Um, for those who are interested, me and Will are doing a free webinar next Tuesday on homelessness law and the criminal justice sector. So basically, everything that probation officers and prison, officers need to know about homelessness law in order to support the people they're working with. And then 2 weeks after that, on the 9th of December, we're doing another free webinar on the Tuesday, 3:30 till 5, just doing an A to Z of homelessness jargon, which I think is going to be incredibly tedious to do, but also very useful, because I think Karis added some more definitions in last week. I think I've got up to a list of about 100 different bits of jargon, and we're not going to go into much detail. We're just going to literally say this is what this means, this is what this means, and just plod through this entire list. So yeah, check that out. If you search for homelessness best practice on Eventbrite, you'll find it.
Is that on the 2nd of December or is it next week?
The 25th of November is the criminal justice
Oh,
one.
is it?
And
Oh,
then yeah,
I
you're
had
still
it
good
down
for it,
as the
yeah.
second. Oops.
And then the one after that is the 9th of December, which is the A to Z of jargon. Um and just right, so just to go back to question 7, um just to add this to it. So they recently received an email from the housing officer saying that he'll make necessary arrangements for interim accommodation. Is this not too late? Shouldn't they accept the main duty first and then offer? No. So interim accommodation is the accommodation you get before the main duty is accepted. That's kind of, yeah. So the interim means it's the interim period between making the application in the first place and then the council reaching that final decision. So yeah, they're doing it in the right order. It just sounds like they need to do it quicker. So yeah, cool.
Sorry,
All right,
Mike,
guys.
can
Oh,
I
you're good,
interrupt?
Paris.
We
Yeah.
left a question from last week.
Oh, did we? Well
Yeah,
remembered.
just because it wasn't anonymized. And we said we'd come back for it. Do you want me to try and anonymize it?
Yeah, that'd be awesome. I've completely forgotten about it, to be honest.
Question 4. So, what if you lived with your partner for a long time and they died and the tenancy was in their name?
Oh yeah, yeah. Sorry, yeah. No, I know. Yeah, Cass, I got you. It's all good. Yeah, I've got the text. Sorry, I thought you meant we like last week in the live stream we said that we're going to kind of follow one up or something.
Oh
So
no,
yeah. Sorry about that. Well spotted.
no, bro. I just
Yeah.
didn't
So
want
yeah,
to. Oh, I was trying to put that. Do you want me to answer it?
yeah. Cool.
I'm welcome, Jim. So, if you're not in the tenancy, you have no right to be there. So, although you've lived there for 12 years, you don't have a right to be there. That tenancy is a contract between the landlord and your previous partner. So, it you can't just pay rent and carry on living there. You have to liaise with the landlord. They might reissue the tenancy in your name and give you a new tenancy and say, yeah, pay us a deposit and we can create a contract. However, if it's a council house, as you said, you live with the tenancy with the council. So it's a council house. They have an allocation, they have a waiting list. So that will go to someone else. There'll be someone else of it. So you'd have to look if you're entitled to a council house, whether you're eligible for a council house. So you have no right to be there and you could be evicted very quickly if this gets to the court stage because that
Would
contract is not in your name.
would if they were married, would they be able to succeed to the tenancy basically, and just kind of would that just kind of just depend on the housing association's policy?
Yeah, it would depend on the housing association's policy. So possibly they're
Okay.
married because it goes to a spouse.
Yeah. Okay. I mean, I did work in a situation not too dissimilar from this when, although the housing association didn't have to, we then made a homeless application, and the council got onto the housing association and said, exercise your discretion
Yeah.
to kind of transfer the tenancy to the surviving partner. But it was a bit of a faff because we had to kind of evidence that this guy had actually been living there, and they were really difficult about it. It's like, you know, we provided a fair amount of evidence, and they just kind of dragged their heels, but we got there in the end.
Yeah,
Um,
so there is with succession statutory right, contractual right, or a discretionary right of the council. So with the council, it's whether there's discretion and what their policy says. So you'd have to go through that process with the council and what your needs are if you have a right to the council house, council flat
yeah,
property.
cool. There's another question just popped into the chat as well, so we'll just do that.
I thought about answering it in case
Yeah, no, that's
is
cool.
there
Yeah,
on a
I literally managed to forget about it. So yeah, I appreciate you bringing it up. Question 9. Housing officer said they'll be working with the client and until they're placed on the housing register via temporary accommodation or private rental sector, main duty's been accepted. What does this mean? Client is disabled. So um, basically, main duty's been accepted, which is the good thing, but accepting the main duty doesn't guarantee you're going to get social housing, as we alluded to already. There's two ways in which the council can discharge that duty ultimately. One is into with a private with the final Part 6 offer, so an offer of social housing. The other is basically an offer of a 12-month assured short hold tenancy. I don't quite know how this is going to work after the Renters' Rights Act comes in, by the way, but we'll find that out later, I guess, which is coming in, I think, on the 1st of May 2026. Can't remember now. But yeah, so basically, this person in the situation is going to be waiting in temporary accommodation until one of those two offers come up. Um, Depending on the circumstances, and the council's practices, it might be more likely that they'll get offered private rented. I guess that as a thing we often say, we haven't said yet that tonight, is that when you get offered accommodation, you really need to accept it. And if there is, if it is unsuitable, then challenge the suitability after you move in. There's a lot of people who think they're going to get social housing, get offered private rented and reject it, and then they just end up with nothing. So you want to just basically make sure. But I mean, it's a good position to be in, or a relatively good position to be in. But that's what they're talking about. The fact that I mean, obviously, depending what the disability is, if it's physical disabilities, then that does increase the chance of it being social housing, because social housing is more likely to be accessible and also more likely to be able to carry out adaptations to the property. So that does kind of sway it towards more likely of social housing. But again, there's no guarantees at all. Um, but yeah, it's a kind of a pity that the housing officer didn't sort of explain that in kind of layman's terms, because it is all jargon. But it's a good position to be in. The fact that main duty's been accepted means you've kind of you've kind of jumped over all the hurdles, and now you're just waiting to be housed. So yeah, cool. All right, guys. We'll see you next week. If unless you want to come to the old free webinar on Tuesday. So I think I said, yeah, just check it out on Eventbrite. You can just log in. There's still we've had over 100 signups, but there's still like some
Ooh.
spaces basically. So have a look at that. But yeah, cheers, Karis and Will. We'll see you all.